Good afternoon. My name is Andrew Samwick, and I am the director of the Rockefeller Center here at Dartmouth College. Let me begin by welcoming the class of 2013 and by welcoming back our returning students. This is going to be an exciting year for anyone interested in politics and public policy. I'd also like to welcome Dartmouth faculty and members of the Upper Valley community whose attendance and participation in Rockefeller Center public events is encouraged. For 26 years, the Rockefeller Center has been proud to host lectures on a broad range of topics in politics and public policy by leading thinkers and practitioners. Please check our website, rockefeller.dartmouth.edu, for our fall term schedule of events. It is a recent tradition at the Rockefeller Center to open the academic year with a program in honor of Constitution Day. We get a week's grace period because we're actually not in session on September 17th. But it was on September 17th, 1787, that the delegates to the Constitutional Convention met for the last time to sign the Constitution and present it to the American public. The Constitution is the singular document that guarantees a representative democracy in the United States and has formed the basis of our freedoms for over 2 centuries. It is my great pleasure to introduce our speaker, Professor Ronald Shaiko, who is the Rockefeller Center's Senior Fellow and Associate Director for Curricular and Research Programs. He will lecture and facilitate a discussion on petitioning government, interest groups, lobbying, and the First Amendment. As citizens, we are granted an unfettered right to contact government officials on matters of public and private concern. Organized groups have similar rights, but their First Amendment rights have been constrained by legislative actions and Supreme Court rulings. In his remarks, Professor Shaiko will analyze the degree to which Congress and the courts have qualified First Amendment rights of organized interests, such as lobbyists and political action committees, and the implications of these restrictions for the operation of our constitutional democracy. This year represents Professor Shaiko's 9th at Dartmouth and his 23rd as a teacher. Professor Shaiko is the person to see if you are interested in the public policy minor, and I urge all interested students to save a place in their winter term schedule for his wonderful introductory course, Public Policy 5. Professor Shaiko also teaches the fall term course, Introduction to Public Policy Research, which is the curricular component of the Rockefeller Center's innovative Policy Research Shop, in which undergraduate students conduct research in support of the state and local governments in both New Hampshire and Vermont. In the spring, Professor Shaiko will teach a new course, Public Policy 51, Leadership in Civil Society. This course is the first offering of what we expect to be a 3-course sequence with leadership as a unifying theme. In November of 2007, Professor Shaiko received the Linda and Paul Gridley Faculty Fellow Award from the Dean of the College. The award recognizes exemplary faculty involvement outside the classroom. Prior to arriving at Dartmouth, Professor Shaiko served as the Democracy Fellow in the Center for Democracy and Governance at the United States Agency for International Development. He has also served as a Fulbright Distinguished Chair in American Politics in the American Studies Center at Warsaw University in Poland. Throughout the decade of the 1990s, Shaiko taught at American University, where he founded and served as academic director of the Lobbying Institute. From 1993 to 1994, he served as an American Political Science Association Congressional Fellow in the United States House of Representatives. Ladies and gentlemen, please join me in welcoming Professor Ronald Shaiko.
Thank you. Good afternoon. I'd like to first introduce my parents who are here, Tom and Joan Shaiko. They've made the trip up to New Hampshire and get to see their son lecture for the first time. So thanks for coming. And thank you all for coming as well. I thought today the topic of petitioning government is a useful one to think about in the sense that we've got a healthcare debate going on right now, and literally scores of organized interest groups are busy trying to convey their ideas and convince policymakers, both in Congress and in the White House, as to what would be fair and proper for our healthcare reform agenda that's going on. So I figured linking that to the constitutional provisions that govern or provide for that petitioning of government would be a useful topic to consider. So beginning with the First Amendment, most of the attention, in fact, in national surveys that look at the the Constitution and ask questions about it. The Petitioning Government clause is the one least known by most Americans. In fact, books have been written on not just the first clause, but parts of the first clause. There are books on just the Establishment Clause and just on the Free Exercise Clause. There's certainly tons of writings on the Freedom of Speech Clause and the Freedom of Press Clause, and then the right to peaceably assemble is also written much about. And yet you've got this petition clause there as the last piece of the amendment, and either A, everyone takes it for granted that that's a given in the Constitution, or they simply didn't know it existed in the first place. So in looking at case law regarding the First Amendment and the petition clause that's in there, rather than having pages and pages of cases that are relevant to that, you literally have two. When I was in Washington teaching at American University, I got to know the late Chief Justice William Rehnquist quite well. And in one of our meetings, I simply said, where's the case law about petitioning? And all he could say at the time was Bill Johnson's Restaurants. That was the only case that he could recall because it was actually prior to 2002 when they took up another case. So it's basically pretty established that the petition clause there aren't a lot of holes in it that you can sort of wrangle around or bring to scrutiny to the Supreme Court. These two cases both involve unions. They both involve the National Labor Relations Board is what the NLRB is. And both cases side, in this case, with the union organizers rather than the owner of the restaurant in the case of Bill Johnson's, or the construction company in the case of the second case. So they uphold that right as an unfettered ability. In this case, it was not only lobbying the legislatures, because it's been interpreted to also hold to state legislatures and local governments as well as to the federal government, but things like protesting and so forth that might fall under the Assembly Clause as well. So it's a pretty sparse in terms of the way that either citizens or organizations have raised the question before the Supreme Court. And so basically it's taken as an accepted part of our political process. There is one exception to that literally began around the time of the Bill Johnson's case, and that is what are called SLAPP suits. Strategic litigation against public participation, that part of the protesting or part of the trying to influence the policy process, particularly around the environmental movement, caused the corporate side of the ledger to respond to that, and basically looking to enjoin the actions of protest groups, social movement organizations, and so forth. They're largely ineffective from a constitutional or judicial perspective. That is, they largely fail. But it's a chilling effect that they have, that a corporation can basically scare an organized interest into behaving itself, as it were, not protesting, not picketing in front of their organizations. So there is that element that still is out there today, and a fairly large, growing literature around SLAPP suits is available to us now. What are the rules of the game established in Washington? Again, as most of those provisions in the First Amendment, they've been qualified, they've been clarified, they've been nuanced by Supreme Court rulings, by congressional action, and so forth and so on. And to the extent that the Congress has gotten its hands around the lobbying industry and what constitutes lobbying, they have at least got for us taken steps to disclose what lobbying is. Now, in this context, it's largely for professional lobbyists. We as citizens individually can take our actions to Congress at any point in time, or to the executive branch, or even to the courts. We don't have to register as lobbyists. We're not being paid to do what we do. But if you are a threshold of roughly $10,000 a quarter, you must abide by the rules. And as you can see, they're fairly recent. Prior to the 1995 Act, there was a lobby disclosure law that was on the books that was created in 1946. The law was 3.5 pages long, and there was not much to it. It defined lobbying as direct contacts with members of Congress. Now, most of what lobbying entails is not direct contacts with members of Congress, so virtually no one had to register under the old law. The 1995 law that began the sort of modern era of lobbying disclosure includes staff as well as members of Congress. It includes the executive branch, including political appointees and career bureaucrats. What it doesn't include is the judicial branch. Well, I'll talk a bit about court lobbying, but from a definitional perspective, from the congressional perspective, anything having to do with the courts is not considered lobbying, whether you're a party to the case or file an amicus brief. That is, 501c3s, most public interest law firms are registered as 501c3 nonprofits, and I'll get to that in a minute. They don't have to file anything with both the clerk of the House and the Secretary of Senate in taking action to change public policy through the court system. So the 98 disclosure technical amendments that were put forth didn't really change much for all intents and purposes, but clarified some things that were left out of the 95 Act. The bigger item is the Honest Leadership and Open Government Act that was passed in 2007. This did a number of things. It took the semi-annual filings of the 95 Act, so you filed every 6 months. It's basically a two-step process. If you're an organized interest, you register as a lobbyist, and then you report what you did as a lobbyist. It's not onerous. This is it. This is the lobby report. It's 2 pages, and all you need to do is fill out the boxes. Now again, this was drafted by Congress, so guess what? You don't learn a lot about what's going on inside Congress. You expose all of what you did as an organized interest, but not who you talked to, because that would expose the members of Congress that they were actually talked to by these people. So it's rather interesting, particularly some of the discussions during the Bush administration of how the vice president was handling certain policy issues and being rather secretive about that. The interesting thing was that the vice president responded, well, I'm allowed to. And basically the court upheld that. Whereas Congress basically keeps it in secret themselves and allows the lobbyists to explain everything about what they spent, but not who they particularly talked to. It also closed the revolving door of leaving Congress and going to work into the lobbying profession. A cooling off period is now in place. Quarterly filings, as I said, and now the money in politics piece is now linked to the lobbying piece. That is, the lobbyists themselves have to disclose their contributions and as importantly, disclose their bundling activities. That is, they're allowed to gather up other people's resources and put them together and hand those monies over to the members of Congress for their campaign re-election committees. So it's rather interesting that they have a provision that it now discloses that. Prior to that, you didn't. But it's also interesting, part of the 95 Act did away with what was viewed more as the social fabric of the interaction between organized interests and particularly members of Congress and their staffs, in that you could wine and dine members and staffs prior to the 1995 Act. Example, when I was working on the Hill, we had a CEO of a corporation come to Washington, take out the entire staff to Morton's, and run up a $2,500 bill. That was perfectly legal back in the mid-90s, right before this act was passed. Now it's not. There are all sorts of exemptions, and we now have a toothpick rule. That is, if you can pick the food up with a toothpick, that's okay, but if you need to use a fork, it's not. So there are all sorts of nuanced ways. There's now the $9.95 lunch special, because that's how much you can spend on a lunch with a lobbyist. So we've got all that. We've got gift ban in place now, and electronic filing, which is also useful from a political science perspective in looking at all this data. They also prohibit the use of campaign funds to fly on private planes. So they really got into the campaign element to this, and that leads to the final piece that I'll talk about, is that the BICRA, the Bipartisan Campaign Reform Act, really changed the face of the campaign finance side of the ledger. And that's where you see much greater qualification of that freedom to petition, as well as the freedom to speak on policy issues. The courts in Buckley versus Vallejo established that money is political speech, that giving money to candidates is equivalent to speech, but at the same time said you could regulate that and limit that. What BICRA did was basically take soft money out of the political party game, if you will, That is where you could actually move your money. Soft money is basically unlimited resources provided by interest groups and citizens to the political process, and they basically move that money out. Not out of the system because it found another route, and I'll get to that in a minute as well. But it basically established new rules, new limits on how much you could spend in each cycle for both individual candidates, political party campaigns, political action committees, and so forth. Here are the numbers. Sorry for the large number, but I just wanted to give you a sense. Since they started filing in 1998, you can see that we've seen a pretty steady increase in the cost, the spending on lobbying, as well as on the number of lobbyists. So I report what we've had for the first 6 months, so you double that, and you'll probably, well, not so much double the number of lobbyists, but double the money. And you can see it's roughly a $3 billion industry in Washington. That is the amount that's actually disclosed on these reports. Does that mean that's how much is spent, or is $14,800 the totality of lobbying that goes on in Washington professionally? The answer to both of those is no, because the definitions of lobbying under this act, including the 2007 Act, basically leave things out. They largely leave out grassroots lobbying, for instance, because that's much harder to regulate. It's much more difficult to track when an organized interest attempts to mobilize citizens to write letters to Congress. That's much harder to track. In fact, there was a case that when the 95 Act was passed, it actually had a grassroots provision in it, and it was driven out by citing a 1958 Supreme Court case called NAACP versus Alabama, in which the state of Alabama banned the NAACP and wanted them to release the names of all of their members to the state of Alabama. Now, the Supreme Court said no to that. And there was an argument in the Senate particularly that, oh, if we have a grassroots provision, we're going to make all these interest groups turn over the names of the people they mobilized. Well, that was never the case. That was never what the intent was. The intent was, A, if you do it in-house, how much did you spend in mobilizing your own members? Or B, if you contracted out and hired a grassroots lobbying firm to mobilize citizens, how much did you pay that firm? So some of the biggest grassroots lobbying firms in Washington show up in these reports. And they're huge multi-million-dollar enterprises. You can mobilize anyone on anything these days. If I went to a company that was a grassroots lobbying firm and said, I wanted a list of women over 50 who wear glasses, who hold gold cards or platinum cards, who subscribe to at least 4 magazines and belong to an outing club or a recreation organization, I can get that list. There's a firm out there that will give me those dimensions right off the bat. Now, I will say I'll put an asterisk next to those who wear glasses, because you used to be able to buy motor vehicle records and overlay those onto your data sets. You can't do that anymore. And they were told by Congress they were supposed to purge their data sets of any motor vehicle data they had, which would show up whether you wear glasses or not. There are firms that literally have up to 110 million names in their databases with up to 50 variables per name that you can buy. So there is a way to buy a grassroots. If you know exactly what your constituency should look like, you can ask for it and they'll deliver it to you. They're going to charge you a ton of money, but they'll deliver it. So the number of actual people working in the lobby industry is closer to 100,000 in DC right now, just at the federal level. That industry, those are those that are reportable. The 14,800 for last year are those that actually march to the Hill and do the kind of work. But they all have groups behind them doing a lot of the monitoring of agencies and looking at legislation and doing the legwork necessary to actually make a good case. And I would argue that the number of 3.3 billion is also quite low when you include things like grassroots lobbying. The best way to conceive of lobbying is as an act of political representation. And there's really 6 dimensions that I think are important to think about in terms of representing yourself in Washington well. And the goal to this is it's not an either-or proposition, that the best organized interest can do all of the 6 that I'll note here. And we'll come back to one that might not make a lot of sense at the outset. So the first is direct representation. That is a physical presence in Washington. And this is the minority of organizations that have full-time offices and staff in Washington. Most of the representation will come in the second set of categories that I'll present. But first, is corporate. In 1920, one corporation had an office in Washington, U.S. Steel, now USX. By the 1960s, there were roughly 150 corporations that had headquarters in Washington. That is, vice presidents for government relations in an office, in a building that worked full-time in Washington. Today, there are over 600 corporations that have full-time offices with staffs in D.C., with likely vice presidents for government relations there. That's not a large number when you consider just the Fortune 1000. I think the 1000th largest corporation in the country is still a billion-dollar enterprise. So you go pretty far down the list. I mean, the lobbying industry itself would be 650th on the Fortune 500 if that were a company. That 3.3 billion puts you that far down the list. So a minority of corporations have physical plant in Washington, full-time lobbying, and yet they all are served in some way, shape, or form. The second is association representation and union representation. Literally scores and scores of these things. In 1955, there were 5,000 national associations. By 1975, there were 13,000 national associations, and today there are over 20,000 national associations, another 125,000 state and local and regional associations, and a couple thousand international ones. So today about 150,000 associations exist around the country. I'll just read you a few. This is out of the DC phone book. So under National and American in the DC phone book, there are 2,500 entries. The National Mushroom Institute, the National Asphalt Paving Association, the National Air Duct Cleaners Association, the National Cheese Institute, the National Corrugated Steel Institute, the National Electric Sign Association, the National Frozen Pizza Institute, the American Fishing Tackle Manufacturers Association, the American Association of Private Railroad Car Owners, the American Butter Institute, and the American Welding Society. So you can see that it's not just the big boys that are playing in Washington, but rather very small niche organizations that have a stake in some political policy outcome and that they feel that they have a need to be in Washington. And what we've seen in the last decade or so, is the hyphenation of the association world. And we now have the National Association of Women Accountants, the National Society of Black Engineers, the American Blind Lawyers Association, the National Hispanic Medical Association. So it's not just the umbrella groups, but then groups within groups that also join that. And if you listen to NPR this past week, we know that there's the Vermont Giant Vegetable Growers Association that produce the 40-pound zucchinis. So they're also organized and probably lobby quite hard in Montpelier. On the union side of the ledger, again, you've got the umbrella organizations like the AFL-CIO that represent roughly 75 or 80 organizations, and we're still at the roughly 12% rate of the workforce in the United States that's unionized. So they're a pretty powerful force in Washington. Ironically or interestingly, they're right around the corner from the Chamber of Commerce. So you've got business on one corner and labor on the other corner, right near the White House in D.C. The third piece of the puzzle on the direct representation side are what are variously called public interest groups, special interest groups, and I also include government as an interest. We can't leave out the fact that governments lobby governments. That if you watch C-SPAN on the Morning Journal, that view of the White House from the window in the C-SPAN gallery, that office of C-SPAN is in the Hall of the States, which right now 47 of the 50 states still have state headquarters in Washington right off the Senate side of the Hill and lobby on a regular basis their delegations and the rest of Congress to make sure that they get their fair share coming back home. So governments are a piece of that puzzle as well. And going back to the sort of the special interest side, there are roughly 3,000 public interest groups at the national level. Now, some are larger than others. The mean size of these groups is about 500,000 people, and budgets around 5 million. So you get the giants of the world, whether it's an association world, the 40 million member AARP, the 800-pound gorilla of Washington politics, to the very fledgling small group that's got 25,000 members and a budget of less than $1 million. They all fall into that category. And our useful in that they provide some degree of balance to what might be viewed as an uneven playing field regarding the corporate side and the association side, which are largely trade business organizations, to the collective action groups on this side of the ledger as well. Now, the key to this piece is that you'll often hear from the public interest groups that we don't take a dime of taxpayer money to do our jobs. We're collective action groups, and we're not at all aligned with the federal government. And I have to laugh when I hear that, in that we subsidize the nonprofit sector in the United States by virtue of the mailings system, so that when you receive a piece of mail that's nonprofit stamped, that doesn't come at the first class rate. It basically costs that organization 7 or 8 cents to mail that piece of mail. And what happens is that the US Treasury writes a check to the Postal Service for revenue lost each year in the billions of dollars. That the Postal Service doesn't, out of the goodness of its heart, deliver that nonprofit mail at that rate. They charge the exact rate that all the other postal mailings are charged, and then bill the government. And we write that multi-billion-dollar check to the Postal Service for doing that. So if you're, Dartmouth College is a nonprofit 501c3. We get to mail out at a low rate to our alums and everyone else. The taxpayer pays that subsidization, so they aren't necessarily free and clear of the government. Here are the top lobbying figures for 2008 by organization. And I wanted to place it in context by showing ExxonMobil is now the Fortune 1 company. It surpassed Walmart. It's got a market value of $345 billion. They spent $29 million lobbying last year. That's 1/100th of 1% of their total worth. So there's a bit of an imbalance, that there's overwhelming influence and it's a lot of money being spent on it. Well, that's change in the couch. That's a penny in the couch for what ExxonMobil does on a daily basis or an annual basis. So it needs to be placed into that context. Probably the best indicator of that is that vice presidents for government relations will never be CEOs. That's kind of a dead-end job. You're the ambassador from the home office over in that foreign land called Washington, and you report back on a regular basis as to what's going on. Microsoft, it took Microsoft 8 or 9 years to figure out that they needed to be a presence in Washington. Gates and company basically, we don't need to be there. We're doing our own thing. Well, then all of a sudden the Clinton administration might start be interested in what Microsoft's doing or not doing in a competitive marketplace. And they're now in the top 25. They went from no presence in Washington to one of the top 25 interests, both politically in the policy process and in the campaign mode. Their PAC is one of the biggest, their Political Action Committee. So you can see AARP's right up there, the Chamber of Commerce, a lot of corporations and a lot of associations end up in that list. And spending pretty serious money, but again, in a larger context, not a lot of money. But this could be, for the corporate side, this could be the most profitable wing of your corporation. If you have a good lobbyist that can change an or to an and, or put off for another year Congress taking up your case, your issue, and it saves your company hundreds of millions of dollars, that staff of 3 in Washington is making your company more than the sales force is selling your widgets. So it often gets overlooked, but I think it's an important piece. But it gives you some context that it's people are spending tens of millions of dollars a year from the corporate and association world to make their presence known in DC. All right, on the other side of the ledger is surrogate representation. That is, if you can't be there, buy a presence in Washington. Now, the associations provide that in part because they are representing usually component parts, that corporations will join those associations. But that's the point I was raising earlier about it's an and proposition. If you're a really powerful interest, you're doing those 3 forms of direct representation and then these 3 forms as well. You're hiring a multi-client lobbying firm to do your work, to really make your case for you. And again, I separate those from the law firms. Now, why would you choose a law firm to represent you versus a lobbying firm? Well, for one, there's a lawyer-client relationship in a law firm that doesn't exist in a lobbying firm. So if you're a conservative entity and you want to keep that relationship and feel like it's isolated and self-contained, you'd more likely choose a law firm to represent you, and that your relationship to that is a lawyer-client relationship versus a multi-client lobbying firm. In the first category, they tend to come in a lot of shapes and forms. They can be subject specialists, that all they do is lobby energy. All they do is lobby healthcare. All they do is lobby some policy domain or some small component of some policy domain. They could be just one part of the policy process, that all they do is lobby the appropriations process, that they're the earmark specialists. They know how to fit money into bills for you. So that a lot of the local governments, a lot of the states, counties, and localities that hire lobbying firms tend to be those kind. How do I get that federal money in my county, into my city, into my town? I spend the summer on a shore community. Most of the shore communities along the East Coast belong to a coalition, an association that represents all of those shore, coastline towns. And most of them hire the same lobbying firm, a company called Marlowe and Company. So that 3 of the 5 surrounding towns around where I spend my summers have the same lobbying company. And all he does is lobby what? The Army Corps of Engineers to rebuild the beaches. So that they make sure that they're in the head of the queue to make sure that they get the beach replenishment coming from the federal government before the next town gets it. So that's the multi-client firms. The law firms are those traditional names you'll recognize when I put the slide up, the biggest of the big that have Washington offices that can provide their clients not only legal representation, but policy representation as well. And then finally, the mega firms, the Burson Marstellers, the Hill and Knowltons of the world, that are doing both PR and GR. So if you're the McDonald's Corporation, you can go to a big firm like this, and they'll do all your national media for you, all your ads for your company, and also develop a grassroots strategy for you in the policy realm, and do all the other pieces of government relations that are necessary to make your case before Congress and the executive branch. And then here are the top firms for 2008. Patton Boggs, Aiken Gump, law firms. Van Skyek is a lobbying firm. Cassidy is unique in that they tend to be the higher ed lobbying firm. Boston University pays them an $800,000 a year retainer to get money to Boston University. Texas Tech is a client of Cassidy & Associates. So that's their stock and trade. All they do is try to find big earmarks or build in earmarks for universities in the process. So again, a mix of law firms, of lobbying firms. Some of the names, let's just see here. Holland & Knight is a Florida-based firm, law firm, but yet has an office in Washington. Dutco Worldwide is becoming one of those conglomerate big mega firms. They've been buying up a lot of these other companies. Podesta, a good Democratic name. Quinn Gillespie, a Republican. So some of the firms are partisan in that they tend to go in one direction. That's sort of going away, though. Most of them are trying to build up staffs that have equally powerful Republicans and Democrats on board. Just on that note, there are roughly about 200 former members of Congress that are registered lobbyists. So it's a fairly small chunk of them. And frankly, they're terrible. They can't get used to being on the other side of the desk. Unfortunately, we had a member of the Pennsylvania delegation, the member of Congress I work for, who lost and became a lobbyist. And he decided that our office was his office, that he was going to come in the morning and hang his coat in our office. He was actually going to hold meetings in our congressional office. And not much you can do with that other than grin and bear it or finally say, look, the day is done, get out, and so forth. So former members tend not to be great lobbyists, although some of the best are former members, because who better to know the process than those that were involved in it? I mentioned that doing all of these is an important thing. So if you're a corporation, it's easy to understand how you could be a corporate entity, an association entity, hire multi-client law firms, hire multi-client lobbying firms, hire law firms, and do all those. But how do you get to a public interest group? How can a corporation become a nonprofit public interest group? Well, you create something called the Center for Consumer Freedom, a 501c3 nonprofit organization, and it's basically bankrolled by corporate America. If you ever have watched 60 Minutes, they recently did a piece on a guy called Dr. Evil. And he is the founder of this organization. And he basically works for Coca-Cola and Wendy's and the National Restaurant Association and a bunch of other organizations, and takes their money and creates these nonprofit organizations that basically sticks fingers in the eyes of the good government watchdog groups for them. So again, with enough resources, you can actually build your own public interest group. Now, you can join this as a citizen, but the 97% of their bankroll is coming from the corporate side. I came across one several years ago called Rail Watch, and they were stressing the danger of railways and moving product on the rails, totally funded by the trucking industry. That, you know, again, a quote-unquote citizens organization trying to protect against railway dangers in crossing roads and so forth and so on. So there is a way to do all six. There is a way to actually have your representation in a variety of forms in DC. And this is just one example of that in terms of the center. All right, on the electoral side, I mentioned 501c3s. They are a part of the larger IRS code, section 501c, 1 through 20-something. And I'll give you the list quickly. Virtually all of them can engage in electioneering except for 501c3s, but that happens to be the largest category. There are 250,000 501c3s in the United States. 2/3 of the nonprofits are C3 tax-exempt organizations. So the difference between a C3 and a C4 is that you as a citizen can give money to both, but you can only write off in your taxes the C3 contribution, not the C4. Now, the consequence of taking that exemption from the federal government is that you cannot lobby the process to the extent that the C4s and the C5s and the C6s can. It's a misnomer, though, however, that you can't lobby. There are a lot of C3s, oh, we're a 501c3, we can't lobby. That's untrue. You can, you simply can't spend, the language is no substantial part, which again is litigated, because what's that mean? You know, somebody's got to define what no substantial part means. Well, it's 5% of the first $1 million you have in your budget and a sliding scale after that. So Dartmouth can, in fact, lobby. It just can't lobby a lot. It really can't take on the cause. And on the electioneering front is verboten. So therefore, when we watch the candidates roll into town and some overzealous students start placing candidate signs on Dartmouth property, that's a no-no. Putting it in your dorm window is okay because that's been ruled by the courts to not be a part of the campus. But putting them out on the green, no. We're a 501c3, we don't do that. So I drive in off Lime Road and see signs and call up safety and security and say those signs are not supposed to be there. So you sacrifice that. The gain is that you can get big contributions from citizens, they can write it off on their taxes, and you can build your organization. You sacrifice doing the direct electioneering that the other groups can do as well. Political action committees. Again, a legal piece formulated by Congress that codified what was previously illegal in terms of how you move money, particularly from the corporate sector, into the policy process in a way that meets the federal standards established by the Federal Election Campaign Act of the 1970s and the various amendments that followed that. PACs are still alive and well. I collect direct mail as a hobby, but it's also a good teaching tool because you can sort of track things. The death knell of American politics 20 years ago was PACs. People against PACs was Common Cause's phrase. Today, they are the legitimate means through which you can fund political campaigns. Political action committees are the safest bet. 20 years ago, they were the worst thing that ever was invented. Now it's 527s. They're the nasty culprits. PACs are legitimate in the sense that there's no pressure that someone further up the food chain in an organization cannot browbeat an underling to give money to the PAC. It's purely voluntary. You can have it deducted from your salaries, but it's a purely voluntary act. So that today it's viewed as rather credible. 527s, on the other hand, not so much, because this is where all the soft money went. The IRS Code 527 has been on the book for years, for decades. And it was kind of, well, interesting, nice to think about. No one was using them for the purposes that they're now being used. And it's overwhelming. So let's just look closely at these. Again, that's the IRS code. And the most important are C3s, C4s, C5s, and C6s. That's where the political action is taking place. So you've got the religious, educational, charitable, and so forth. That's the lion's share of what we view as nonprofits. C4s are civic leagues, social welfare organizations. They are the ones that used to be C3s but ran afoul of the IRS for doing too much lobbying. Sierra Club, up until the Nixon administration, was a C3. And the Nixon administration didn't like what they were saying about the Nixon administration, and they audited them and found, lo and behold, they were spending way too much money influencing public policy, so they simply changed their tax status. And what did they do? They created Sierra Club Foundation, which is a C3. So they told all their big donors, give money to the foundation. For the smaller donors, and you don't want to write it off on your taxes, send money to the C4. So today, Sierra Club is this multi-headed monster that has a couple C3s, several C4s, and a public interest law firm that goes with it. C6s are the business side. So all those associations that had a business connection, they're all 501c6s. And that's a pretty big chunk. And again, they're business organizations. They are lobbying for an economic interest, but they're viewed as nonprofits from an organizational perspective. And then you see the rest of them there. The PAC contributors. This is the top 10 list for the last cycle. The data is not quite good enough for what's going on right now to see any patterns emerging. The interesting thing here, it's got corporations, it's got associations, and it's got unions up there. You can see the level of political pragmatism in some and the ideological clarity in others. That is, when you get to 98 to 2 or 95 to 4, that last one, does anyone know what that might be? The American Association for Justice? That's yet another label for the trial lawyers. That's how they couched themselves in the 2008 cycle, the American Association for Justice. And they gave overwhelming to Democrats. But you can see the realtors kind of split. They're playing the power game. Who holds the power, and should we hedge our bets? So they're given to people, they're giving to ranking members as well as the committee chairs. Whereas the IBEW, the electrical workers, there's 98 to 2 for the Democrats, and so forth and so on down the list. So you just get a sense of who the bigger players in the PAC game are. And important to note the numbers. So the top PAC is $4 million. The top 527 is $27 million, and that's down from the last cycle. In 2004 cycle, the top PAC, the top 527 spent $79 million. So we have a drop-off in the 2008 cycle for that, but still some big numbers. The other big change in this is that in the top 25 list for the 2004 cycle, 4 Republican-leaning 527s, 21 Democratic-leaning 527s. A little more parity here. If you can see, Citizens United is conservative. We'll come back to them. The college Republicans, Patriotic Majority is conservative, GoPAC's conservative, and the rest are more left-leaning. So a little more parity in this cycle. The numbers are down in this cycle. $500 million was spent by 527s in a roughly $3 billion cycle. So it's a fairly big chunk. And then I have who does both. And those 4 firms, the ones with the X's, have not only a federal PAC, but a 527 as well. Citizens United makes the top 10. Does anyone know anything about that group? No. If I said Willie Horton, does that ring a bell? 1988 presidential campaign, the infamous Willie Horton ad, that's Citizens United. But it's also Hillary the movie, is Citizens United. So we have a special session of the Supreme Court in the summer, no less, bringing them back from their hiatuses, or hiati, to hear this case, Citizens United versus the FEC. This is a big case. This is a big case because it's basically declaring this public interest group a corporation, a corporate entity, and what can that corporate entity do? And back to this qualification of constitutional rights. How far can you limit that? Can you basically tell someone that's producing a film, not a commercial, not lobbying Congress, but a film, that they can't put that film out during an election cycle, 30 days before a primary? Because that's what the Bipartisan Campaign Reform Act says it can't do. So this is one to watch as to whether, and if the Supreme Court says it's all right for Citizens United to do that, it's going to blow the lid off the whole limiting around elections activities of this. Because this is not, if it were simply what is viewed by the Federal Election Commission as express advocacy, vote for, vote against candidate X or Y, that's express advocacy. The issue advocacy piece is basically candidate X or Congressperson X has done a horrible job voting for the environment. Call Congressman X and tell him you're not happy. And that ad runs the day before the elections. Do they really want you to call? No, they want you to go out and vote against them. But the FEC has said that is issue advocacy. You've never expressly told the voters to do something other than call their congressperson. So that's what the Supreme Court is going to be wrestling with in this particular case, as to whether that's how stringent they want to be on limiting the various actions of what are corporations. All right, so what constitutes petitioning? As I said, for individuals, you can call, you can write, you can email, you can Twitter, you can Facebook, to your heart's content. And you'll never run afoul of any of the lobbying laws, because citizens is basically an unfettered right, unless you're doing something illegal in that act, or calling for the overthrow of the government, those kinds of things. But if you're sticking within the rules, you aren't limited very much at all for that. On the front of the paid lobbyist side, there is disclosure and reporting. One piece that I didn't talk about, under the 95 Act, they declared corporate entities globally to be similar. That was one thing under the 46 Act, that only American companies fell under the lobbying provisions. If you were representing a foreign company, you had to register as a foreign agent under the Foreign Agents Registration Act of 1938. Today, the only people that have to register as foreign agents are those that represent either A, foreign governments, or B, foreign political parties. So if you're lobbying for a Swiss company, you're treated just like anyone else. You file the lobby reports and registration just like any other entity, which kind of flew under the radar screen when that was passed, that we basically said, it doesn't matter where you're from. You have every right to lobby our political system. So only foreign governments have to register as foreign agents. And that's a rather onerous task, because you actually register with the State Department in that case. There was an infamous Spy magazine spoof where they took a reporter and decided to make that reporter representative of an African dictatorship, and see would any company actually get paid to represent them in Washington. And one that was up there in the top 10 list did, and of course was spoofed to no end in the paper when that was brought to light, that they would actually represent an African dictatorship in Washington. So, in terms of what constitutes lobbying, how you do it, members and staff, personal and committee are certainly fair game. Direct contacts, the grassroots piece is a murky area, and not some on their own volition will report those things, others won't. They don't have to. And then I put the astroturf term. You're already hearing that in the healthcare debate, that's artificial, it was made up. Lloyd Benson coined that phrase a number of years ago. And he was, at the time, the senator from Texas, went on to be Treasury Secretary. It's something that's not spontaneous. And frankly, a lot of what goes on in Washington is astroturf. The capacities of grassroots lobbying firms are endless. You can get a call from a grassroots firm that has some knowledge of where you stand on issues and inform you of an issue that's before Congress and ask how you feel about that issue. If you agree with the client's position, they say, would you like to tell your member of Congress that? And you say, yeah, sure. And they'll say, hold on, I'll patch you through, and literally hook you into that congressional district office. Again, for a price, you can get that. And this law doesn't really capture much of that. The other thing I want to put up there, that I put up there, is coalitions. It's another gray area in the law as to what constitutes a coalition. It says if you, as an organization, pay into a pot $5,000 in any quarter in order for that coalition to do something in Congress, you must register. But if you form that coalition in order to do a national media campaign and spend millions of dollars that doesn't constitute lobbying under this law, you don't have to register. And a lot of coalitional activity is just that. It's doing the grassroots piece. It's pulling the collective resources of a bunch of organizations together to make their influence felt in the policy process. So it misses that. The other piece of that is internalized coalitions. Caucuses. Inside Congress, members of Congress can come together and put themselves into they're called CMOs, Congressional Member Organizations. They have no status on the Hill, but bring together like-minded people. NPR this morning talked about natural gas versus coal. There's a coal caucus in the Hill. There is no natural gas caucus on the Hill. Guess who wins more often? The coal caucus does. So there is a way of internalizing your interest as well to get what are called champions or horses on your side. Members of Congress that feel strongly about your cause and are willing to champion that, even if they don't have committee jurisdiction, they don't serve on the right committee, they're willing to take up a cause. They can be economic in nature, they can be social, they can be ideological. There's a progressive caucus, there's a conservative caucus, there are a bunch of those. There are regional caucuses, the Rust Belt Caucus, the Northeast Midwest Coalition. So there are a number of these things that can bring people together to get them working on your issue from the inside. And you can fund them. Most of them have off-campus, off-the-hill 501c3s. The member that I work for founded the Congressional Fire Services Caucus. And it was the largest on the Hill, because who's going to be against that? What member of Congress say, no, I don't want to belong to the Fire Services Caucus? So there's the Congressional Fire Services Institute, off the Hill. Guess who funds it? The fire unions, the sprinkler societies, the fire engine makers, and that's how they get their funding. So there are creative ways to do just about anything. And to get yourself inside the game as an interest is equally, if not more important, to have those champions that are always looking out for your issues. Why is it the case that in the larger scheme of things, Ukraine gets more support from the United States government than Russia does on a per capita basis? Because the Ukrainian Americans love Ukraine and Russian Americans hate Russia. And therefore, they're much more, the Ukrainian American lobby is powerful in Washington. We've spent $1 billion of taxpayer money cleaning up Chernobyl, just for your information. That's what we spent. Since Chernobyl happened, $1 billion of US government money has gone to clean that mess up. And that's because the Ukraine lobby is pretty darn powerful in Washington. So however you can get your influence in the process, you're doing well. On the executive side, we'll quickly go through these. Obviously, lobbying the president is an important thing to do, but not the only thing to do, or is surrounding White House staff. There is an office in the White House called the Office of Public Liaison, but if you have to use that door, you're not very powerful as a lobbyist. That's the generic door you walk through to try to get an appointment with a president or someone in the White House. And largely, it falls into this sort of ethnic groups that go into that door and other kinds of folks, but not terribly important. Lobbying the bureaucracy, on the other hand, is a much more nuanced process. It's not, you don't lobby executive agencies the way you lobby Congress. It's a different game altogether. They don't have constituencies. They don't get reelected. Their permanent presence in Washington. Their administrations come and go. The bureaucracy lives on. So you deal with them in a different way. I just put two acts of Congress up there that change this, what is often viewed as a pluralist model of governance in American society. That really, what government's all about is either A, they're a punching bag, or B, a referee. And all they do is measure the sheer weight of all these interests trying to get their way and declaring a winner in this pluralist model. Well, what these two pieces of legislation do is walk us a little bit down the road toward either a micro-corporatist or some sort of corporatist model where you're sitting co-equally around the table making public policy. In the case of the Federal Advisory Committee Act that was passed in '72, We've literally have had thousands of federal advisory committees formed in virtually all agencies and departments, producing scores and hundreds and thousands of reports. Are they actionable documents? No. But can they move an agency in a certain way? They certainly have the possibility of doing so. GPRA, on the other hand, the Government Performance and Results Act, actually mandates the inclusion of quote-unquote stakeholders in the policymaking process. You cannot create a strategic plan for your agency or department without including stakeholders in that decision-making process. And it's created a whole new industry of facilitators in Washington, because the agency administrator can't sit at the front of the table and conduct the meeting. A disinterested third party has to come in and get paid to actually interact with the adults around the table. But if it's the Department of Energy, you've got to have the energy companies sitting at the table, you've got to have the environmental groups sitting at the table, and collectively you're supposed to make a strategic plan for that agency or that department. And oh, by the way, you have to report back to Congress on an annual basis how well you've done in meeting the goals and producing the results that the Congress asked you to do the previous fiscal year. Not outputs. So you can't simply say, we zeroed out our budgets. You have to answer the so what question. What results did you produce as a result of zeroing out your budgets and spending all we gave you last year? And of course, you get graded out. Some agencies do very well. Other agencies do terribly poorly. When I was working at USAID, the USAID team and its, quote, stakeholders went to Congress and lobbied. Well, the Republicans at the time ran to Congress, or ran to the White House, and the Democrats ran to the Congress and exempt us. Write language that exempts AID from GPRA, because we're doing democracy work. How can we possibly measure on an annual basis progress toward democracy? What widgets are we counting up to make sure we've made the Slovak Republic more democratic in the last fiscal year? They lost. Neither the White House budged nor Congress budged, and they still had to report. Quantitative empirical data, not narrative, can't tell a good story. Here's what we did in Uganda. No, that's not sufficient. Rather, numbers. Number of town hall meetings held divided by whatever squared. You needed some sort of empirical evidence that you've actually produced democracy in the world. So as you might imagine, that was a bit of a touchy point for the workers inside the agency. Then finally, the rulemaking process, that you've got formalized structures put in place, again, by congressional mandate, passing legislation that defines what those procedures should look like. But what's built into those? Public comment periods, all throughout the process, where we as citizens, or more importantly, those organized interest groups, making their message heard. So you can, in fact, grassroots lobby an agency. They might not treat it the same way the Hill would treat it, but you can do it. You can flood letters in during the comment period. They might, particularly when they're all the same, when the RNC tried to do it to the FEC, they saw right through it. They got 13,000 letters, but they were all the same. At least the Democrats on the FEC said, thank you very much, but we're not going to read those. So you can have that influence in the process. But knowing how that game works, there are lobbying firms that only do executive branch lobbying. They never set foot on the Hill. All they do is figure out how the rulemaking process works or where they can fit in their client's interest in the process. And then the last item, there is in fact a law on the books that prohibits executive branches, agencies, in the White House from reverse lobbying, from trying to convince us of their policies. Now, what's exempted when President Obama goes out and gives a speech, or Arnie Duncan comes up to New Hampshire and talks about the family initiative that the president has, that's perfectly legal. The political appointees can talk up their policies all they want. What they can't do is hire PR firms to do it for them. Now, the law passed in 1990 put a number of 5,000 on it. That's roughly $75,000 today. So up to $75,000 can be spent on trying to make their case to the American public. In 2000, the Clinton administration spent roughly $39 million on public relations firms. In 2004, the Bush administration spent $88 million on public relations firms. So we got 100,000 cops out of the Clinton administration and all the orchestration of that event that took place, which by any stretch of any analysis, violated the Anti-Lobbying Act, the amount of money they spent doing that, by hiring firms to drum up support for the 100,000 cops in the crime bill. Go ahead to No Child Left Behind. And the Bush administration pitching that idea to the American public and spending far more than the $75,000. And the case in point that sort of broke this whole story was Armstrong Williams. That it was uncovered that Armstrong Williams had a $241,000 contract with the Department of Education to go on his radio show and pitch the No Child Left Behind to his audiences. A total violation of federal law, and finally someone called him on it, and the FCC threw the book at him, and he's no longer on the air. So personally, he suffered rather dramatically. It's not clear the Bush administration did, but there is a statute on the books, sometimes, often rarely used, but it's there, and the executive branch shouldn't be out there pitching their ideas and using public funds to do it. Finally, the courts. Again, it's not lobbying. It's not viewed by any government agency or regulatory entity as being lobbying, but you can still use the courts. And in that model of policymaking, that might be your roadblock. That you lost in the Congress, you lost in the House and the Senate, you lost in the implementation of that policy, but now you just step in there and say, I'm going to sue the government. This is an infringement upon my rights or my corporation's rights or whatever, and you're going to file a case. So that any entity can do that. But there's a nice literature that really makes it clear that repeat players win out over one-shotters all the time. That if you're a constant player in the court system, you're going to win more likely than those that hit it for one shot. What we've seen in the evolution of public interest law, though, since the early 1960s, public interest law began in urban law firms where the associates, the partners decided, we need to provide services pro bono to those that can't afford to use the judicial system, can't afford to use the courts to their benefit. That was the evolution. That's where it started. It's now evolved into public interest law where interests unrepresented in the political process are being represented by public interest law firms. Not so much individual citizens who need to have something done on a landlord-tenant issue, but rather issues involving affirmative action at the national level, or at college admissions, the University of Michigan cases, those kinds of things. So we've seen this change over time. Does that mean that law firms aren't providing pro bono work anymore? No, they are. But the concept of public interest law has taken on a very different shape, but has had positive consequences of having class action suits where those individual one-shotters can pool their resources and come together and act as a class of citizens against a major corporation. So that the Ford Pinto back in the day that had the gas tank that exploded if you hit it from the back, all those owners could get together. ATV owners, where the ATVs kept flipping over, you could get together as a class of citizens and sue either the corporation or sue the federal government. There's been a bit of a response from the bench from this in developing what is called fee shifting. That if you bring a case that has no merit and just to tie up the court system, in addition to getting an award from the court, they can also burden you with the fees of the other side in the game to prohibit or have a chilling effect on people bringing cases that aren't necessarily meritorious into the overcrowded judicial system. The second way you can do it is file amicus briefs. Any non-party to a case is perfectly able to file an amicus brief on a federal case. Sometimes they matter, sometimes they don't. When do we know they matter? Well, when they're cited in the opinions. When a justice, either concurring or majority or dissenting opinion, cites the briefs from a third party, then you know they matter. Sometimes they line the birdcage. Sometimes they don't get read. More often than not, they're done for purposes having nothing to do with the case, but rather to mobilize their membership bases. It's a good way to say, hey, we're in the game here. We filed a brief on case X that's before the Supreme Court. But we might have been one of 47 filing cases, all saying virtually the same thing. But their members might not know that, so it's a good way of mobilizing their bases. The next is lobbying the nomination process, and this is sort of a growth industry. Beginning with Bork, pretty much, of seeing how you can expand the process, slow it down, get your resources mobilized, and go after people. And this is sort of the most telling piece of how the Constitution changed of having at first an appointive body, and that's why a lot of the powers given to the Senate were given to the Senate, because it wasn't an elective body. It wasn't one exposed to direct public opinion. And so now that we've got elective senators, you can actually lobby the process much more clearly and have a direct impact and say, you decide to vote for this Supreme Court nominee and you might lose your next election. So we've seen that change over time as well. And then finally, can you lobby judges or justices? There's a very famous case of Tommy the Cork Corcoran, who was a big-time lobbyist back at the turn of the century. He actually went into a justice's office and tried to get him to change his opinion, was summarily thrown out by the Supreme Court police. So you don't do that. But having said that, they don't live in a vacuum. They read law journals. They read the Washington Post. They go home at night. So they're not sequestered. Whatever societal impacts can be had on that, they go to church. We're now at the point we've got 6 Catholics on the Supreme Court. 6 out of the 9 are Catholics. We've never had that in our history. We've never had a majority of Catholics on the bench. They go to church. Is that going to have an impact on them? Justice Rehnquist, there was a case before the Supreme Court. He's a Lutheran, as I am, and that's kind of where we met. A case involving a Lutheran church and having a classical radio station, and there was a hiring practices case in where they decided they didn't need to hire an African American because they don't listen to classical music. Now, obviously, they lost the case, but it actually made its way to the Supreme Court for a variety of reasons. He wasn't, he was setting aside his Lutheranism and making a judgment based on his ideology as a jurist. There were other cases. The pastor, when the Texas sodomy case came before the Supreme Court, the pastor actually preached from the pulpit on that issue and where Lutherans stand on that question. And he didn't rule the way that Lutherans would have. But the pastor got his 2 cents in. So who knows what they bring to the bench with them? Interestingly, Chief Justice Roberts articulated last year the notion that he thinks that the Supreme Court ought to start behaving as judges and not policymakers. And we're to the point now where we've got career judges serving on the bench and not people that have come out of other realms. That are, Rehnquist was in the Attorney General's office. Sandra Day O'Connor was actually a legislator, served in the legislative branch. So they've had other backgrounds. We're now to the point where all 9 are just career judges. And he was sort of hopeful that we get into a different mode of thinking about how judicial decisions are being made. So again, to sort of pull it all together, hopefully this has sort of demystified the process a little bit. I don't come down on the side that the lobbying industry are a bunch of influence peddlers and hired guns. There are sort of the equivalents of Bertie Madoff in the lobbying industry. Jack Abramoff comes to mind, who basically defrauded a number of Native American Indian tribes in their lobbying process before Congress. So there are bad eggs. But I tend to lay blame. I tend not to scapegoat the lobbying industry when things go wrong in Washington. I've yet to see a lobbyist take a card and put it in a slot and vote yay or nay on anything in Congress. Members of Congress do that. If they're disproportionately influenced by organized interest, that's their problem. That's their problem. That's the elected officials' problem. In the executive branch, the same thing. If they're being swayed by interest, we ought to hold the administration accountable for that. Organized interests have that unfettered right to do whatever they do. Are they self-interested? Sure they are. That's why they're in Washington. Is it totally representative in the political process? No. There are certain interests that get shut out of this process. But to say that somehow it's the fault of those that try to influence public policy for what they view as the greater good, I think is an argument that doesn't hold water when you analyze it clearly. Should the AARP be a force in Washington politics? Well, they've got a 50% market share of all those over 50 in the United States. Now, is that the case that all those over 50 hold the same political views? No. And hopefully they're somewhat constrained by their behavior. There was a little of a rumble that AARP lost 60,000 members in August because AARP took a stand on part of the health care debate. Well, they lose 300,000 members a month. 300,000 members die or go away in AARP every month, and yet they've got 40 million members. They're picking up 400,000 members a month. There are 2 zip codes for AARP. Just for the organization, they have 2 zip codes. They handle that much mail a year. So it's a big organization. Should they have impact on the policy process? Why not? They clearly represent a big group. Should they be punished because those under 30 have no such group? I don't think so. I don't think that's their business. They're representing their constituents. If the other constituents aren't organized, that's their fault. So if there wants to be a group to be created that represents those 40 and under, knock yourselves out and go do it. But that's not the other interests' fault. They're just doing what they think is best for their constituencies. Does it all add up to the public interest? No. But that's what we elect people to decide for us in a representative government. They're supposed to figure out what the public interest is, not the organized interests that have a constitutional right to make their case in Washington. So I'll leave it there and take whatever questions you've got. If you've got a question, just raise your hand. We've got 2 microphones that we'll be glad to come to you. Got one here.
Well, I agree with you.
Yeah,
I agree with you completely on the right of people to lobby and try to persuade. But what happens when you add money to it? Campaign contributions. What if you get campaign contributions and you vote because of those? Isn't that unethical, and isn't that bribery?
I think that's the toughest part of this puzzle. I think the fact that we now have disclosure that links the two, again, that original 1995 Act was calling for an agency like the FEC, and all the data would have been coordinated with campaign finance data. So at least we could draw the lines to see, was in fact money moving from member to, or interest group to member, and they were voting accordingly. What political scientists have been able to prove is that money buys access. We can empirically demonstrate that with all of our models and whoop-de-doo things that we can do with numbers. We can prove access. We can prove that money buys you access. And that's one of the strangest outcomes of the campaign finance reform that has taken place, in that the nonprofit sector, who should be most concerned about access vis-a-vis corporate America, pushed a piece of legislation that basically said, we are taking the social aspect out of the game, but if you have money, you can hold a campaign fundraiser at night, hand the member of Congress $50,000 and have access to him and his staff after hours. So that's perfectly legal. If you give them money, you can have access to them. But if you don't have money, or you're not allowed if you're 501c3, you basically have the 9 to 5 schedule to fit your piece of information into the puzzle. But fundraising you can do all the time and give them money, and through that have a nice conversation about what's before the Congress and so forth and so on. So you're absolutely right. It is the piece that's most troubling, but because the Supreme Court of the United States has declared it to be part of symbolic speech, they'll limit it, but they won't prohibit it. So then the other option is what? Take all the money out and publicly finance campaigns. The American public is not on board there. If the tax checkoff is any indicator of that, that general fund is going to not be enough to fund the next round of elections. It started out in the low 20s. It's now down to close to 12%. That aren't even willing to say, you're not losing the money out of your return. The General Treasury will pay the money to the campaign finance fund. And only 12% are willing to say yes to that. That not one dime is going to be taken out of your return if you check the box. And 88% of them don't check the box. So public financing has virtually no traction, at least today in American society. But I agree with you that that's the notion that you could actually bankroll. But again, the standards, apart from the 527s, how much can you give as an individual? How much can you give as a political action committee? And in that scale, it isn't overwhelming. That if the largest political action committee only gave $4 million, and you figure there were 435, theoretically 435 House races, that doesn't go very far in the larger scheme of things. So it's not like you're backing up the Brinks trunk and giving somebody $1 million. You can't do that. It's illegal. So we've qualified that constitutional right. We've said, yes, you're allowed to do it, but only by this much. And we could tighten that up further. That would be healthy too. Go ahead.
Ron, do you have any short list of suggestions on how to make the system any better?
Well, I would do a lot. What I would do, I don't believe you can limit the rights of people that are lobbyists. There is some limitation of rights in that 2007 Act of saying what they can't do or what they must disclose. I would tell members of Congress that they're not allowed to solicit money from registered lobbyists. Make that illegal. If you're a registered lobbyist, particularly if you represent a nonprofit who can't give money into politics, what a burden you bear when you get that fundraising letter from the member of Congress. Come to my beef and beer and give me a $500 check. You can say no, but what are the consequences of saying no? They know they ask you for money. They know you didn't give them money. What's that do to your access in that office? And that's all the way up the food chain, that not only do corporations give money legally, but all the employees can give individually. And members of Congress will know that. Did this CEO give me the max? And if not, why not? So I would make that the first rule. Second rule, I would say you cannot be a registered lobbyist and be a PAC director. 35% of all PAC directors are registered lobbyists. The same person that hands you the check is trying to convince you to do public policy. I think that's something that can be fixed. You simply can't be both. You cannot show up on both the FEC forms and on the lobbying forms. Take that out. You cannot serve on steering committees. I had a lobbyist in my class at American University who in one cycle served on 47 steering committees. That is the campaign committees of 47 members of Congress. He was charged with fundraising for 47 candidates. In addition to his PAC maxing out to all of them, now it was again one on the top of the list that it could max out to 47 candidates quite easily. He had to write his personal checks to all of those and then bundle money for all of those. I think that's an outrage. That should not happen. So I would disassociate or disaggregate the financing of elections with the lobbying process and make it illegal to be both. So those are two quick ones just off the top of my head that I would immediately put into law. Yeah.
Thank you. You mentioned financing elections. The Citizens United case, what do you think is going to happen?
I think, just my gut feeling right now, is that Citizens United's position would be upheld. That they're going to say this is unworkable. The best way to make this law workable is to say, if Congress is in session, you can lobby them. If Congress has adjourned, you really can't lobby them. Then it is a farce to do issue advocacy. So that the deadlines they ought to fix are not arbitrary 30-day ones. If Congress is doing business, you should be able to lobby them doing their business. If they're not doing business, you shouldn't. That would make more sense to me than simply saying 30 days before every primary you have to stop doing what you're doing, regardless of whether it's express advocacy or issue advocacy. That, to me, if I'm a jurist, I'm ruling that to be arbitrary. What's so special about 30 days out? Why not 60 days out? Why not 90 days out? So I have a sense that they're going to find a problem with this. Again, it's a movie. It's a harsh movie. It's damning to the chief star of it, but it's not telling you to go out and vote expressly against. Okay.
It's the big money
Right.
going into this sort of.
In the 527s,
Yes.
like Citizens United. I'm not a big fan. I'm not a big fan of 527s. It was. A 527 is simply something in the Section 527 are political organizations with basically anything you want to stick in that pot as a political organization. So you can be a 501c4, you can have a political action committee, and you can have a 527. The difference lies in what the limitations are on PACs and on the 501c4s. There's virtually no limitations as to how much you can give a 527. The 2004 cycle, that was the Millionaires Club. That's where you saw Soros and company giving millions of dollars into a political organization called a 527 and spending that on the electoral process. That to me needs to be fixed. But you know, as I said, in the 2004 cycle, 21 of the top 25 were Democratic. In the 2008 cycle, there was parity. The Republicans figured it out. They were behind the curve. They now brought themselves into the curve. And it's $500 million that's moving in that way. That I'll tell you why this was a problem. The damn political parties never behaved themselves and spent the money the way they were supposed to spend. Soft money should never be in the political process anyway. Soft money is clearly defined as party building. And they did do that. And the DNC is a more beautiful building than the ugly building it was because they used soft money to refurbish the place. That's what party building is. But the problem was the political parties were using soft money for political purposes, electoral purposes. Never the intent. That's why they got their hands slapped. That's why BICRA, no soft money to political parties. That was the punishment. But they just allowed the valve of 527s to be wide open. So all that money that was moving to political parties, which I'm a strong parties advocate, I was in favor of, but they weren't using it correctly. They should have been out there building, they should have been doing the Dean methodology of going state by state and rebuilding the Democratic Party. He had a strike against him because he didn't have the soft money that would have been there to do just that. He did a pretty decent job of it anyway, but he could have had more money to actually go out and build parties. So it's this amorphous entity within the tax code that you can stick virtually anything in, and you can be unlimited in how much you spend in doing those. So that's a bit of a problem. Yeah.
My broad question would be, there seems to be a great amount of money and a great amount of effort being ferreted into like the lobbying industry. I guess my overhanging question is, I mean, is it really worth it at the end of the day? What is the greater impact?
Well, there are two answers to that question. One, it isn't a great amount of money. We spend more as a nation on cat food than we spend on both lobbying and on campaigns combined. So put it in that, I mean, $3 billion is $3 billion. That's a lot of money if you put it on the table there. But in the larger scheme of things, it's not. When you're talking about a budget deficit, the budget deficit of 150, a budget of $3+ billion or $1 trillion, $3 billion, that's not a lot of money. So that's one of sort of how much is a lot of money when it comes to electing people to make public policy when you're controlling $3 trillion worth of budget. So that's one answer, that maybe it's not a lot of money. And the second part of your question?
Yeah, is there a greater like societal impact?
Right. Again, you can view it in two different ways. The problem with this money is it doesn't represent anywhere close to the majority. We're talking about less than 1% of the American public's ever given one dime to any candidate or party. It's a very elite gain. There's a great book that colleagues of friends of mine that work in Washington wrote called Serious Money. And what they did is they go to the FEC reports. If you give over $200, your name appears. And then started putting them in categories of everything up to the max and start breaking them out. And it's not a cross-section of American society that's doing this. It's not at all. It's a very elite sector that's engaged in policy and politics in a very serious way. Now, there are those that say, as it should be, that there's the George Wills of the world that say, good that we only get 50% people voting, because the other 50 don't know anything anyway. They shouldn't vote. That's one view of the world. It's a very much of a Burkean model of representation. The kings, the lords, and the judges are really the ones with the knowledge base to make sure that things go well. And we as loyal subjects should be thankful they're there. Now, I don't particularly buy into that, but that's one view. That's one view of how the policy process works, or should work. And there are those that believe that. It's just about right for some people. Having 1% of the population funding politics and 10% engaging in it in a serious way, writing letters to Congress, giving money to candidates and those kinds of things, that's just fine. I'm a bit worried. What we've seen is an increased disengagement in politics, and it's generational. Your generation is worse than my generation, is worse than the generation, or worse than the generation before. And that's largely because the parties themselves have disengaged you. They're not speaking to you. They're speaking to the wealthy people that fund them. And therefore, you don't feel like you've got a place in either political party. That's unfortunate. And again, I'm a strong parties person. I think they matter. But right now, they're not mattering a whole lot. And the parties need to get on top of that and fix it soon. And Democratic Party's in a little bit better shape than the Republican Party is right now, but they're not in great shape either. The independent vote, the middle, is, unfortunately, they're the least organized in the political spectrum, those that fall in the middle. Yet they're the largest plurality of voters are in the middle. But we don't tend to be organized as well. So, other questions?
Ron, just an observation. And I guess I've become a little more cynical as years have gone by, but I look at this health care issue and I see Max Baucus, head of the Senate Finance Committee, reportedly has received $3 million from the insurance industry and the pharmaceutical industry. And obviously that's not just to get your foot in the door. And as a result, he has refused to let anyone bring to his hearings a discussion of a government plan or a single payer plan. And that has been true. The monies, in addition to his, that have gone into this thing to block it. And I look at Western Europe and all the other civilized countries in the world, and they have the most efficient health systems available. And I get the feeling that listening to you and all the money that's swooshing around in Washington and all of the gimmicks to try to get it in there and influence politicians, the temptation is so great for those guys and girls that are representing us. I think we're losing a touch with our democracy. Any comments?
No, I agree. I mean, I think I should have prefaced this whole discussion that this industry is built on having nothing happen. The most successful outcome for most organized interests in Washington is the status quo. That more of the permanent interests, those that do all 6 forms of representation and spend a lot of money at it, their goal at the end of the day is having nothing happen. That they've spent 240 years getting it the way they want it, and they're not interested in anyone coming in and changing that, whether it's a Democratic president or a Republican president. Do they have wish lists? Sure. The insurance industry has wish lists. They want to get something done, but they'll settle for nothing happening before they ever give up their status quo position. And if the majority of interest in Washington follow that way of thinking, should we be surprised when nothing happens? Or that incremental things happen? That, all right, we're willing to just, I mean, the first thing they did was children's health care. And I would argue that if the budget situation weren't so monumentally a mess, that what on other times $35 billion would have actually looked like a lot of money. But because we were in such dire straits, that $35 million was just another $35 million to the $700, $800 billion we're going to spend on the bailout. So that was sort of a freebie. Boom. So we checked that box and got that done. But under quote normal circumstances, most of these interests are just don't do anything. Or if you're going to mess with us, do it at the margins and we'll still survive. And maybe we'll sue you down the road anyway and delay it for 2 more years. Or we'll tie up the rulemaking process. Or we'll hold our breath until the next administration comes in and they're going to kill it anyway in the rulemaking. They're going to just abolish the ergonomics rule, for instance. The first thing that Bush did when he took office. 7 years of work. No, we're not doing that. We're the Bush administration, not the Clinton administration. So I'm equally depressed, might be too strong of a word, but there's a reason why foot dragging occurs. There's a reason why permanent interests win in this process. They've they've situated themselves in such a way that no one-shotter, no fledgling public interest group can break the logjam that they've built up over time. You know, we shouldn't be, I'm not overly concerned or stunned by the fact that a guy like Balkus would get that kind of money from those interests. That's exactly where they belong, putting their money. If you're not funding the Senate Finance Chair, who else are you funding? You know, you got to put the money where the power is, and these interests are, again, they're pragmatic. If the Republicans had been in control right now, the Senate, you know, the Senate Finance Chair would be getting equal amount of money from those interests. The one thing about them is that those permanent interests are much more pragmatic, much less ideological than some of the more peripheral interests that are out there. Quote, fighting the good fight. The permanent interests are interested in power and who has it and how can we control that. And they frankly do a pretty good job of it. And again, I can't fault them. That's why they're there. And if they're there and other groups aren't, they're watching the entire process and other groups can't afford to watch the entire process, that's not their fault. But the members of Congress and the members of the career bureaucracy in the White House should be looking out for that larger good. That's their job, to keep their eye on that ball. If they're so influenced as to lose that sight, then we need to throw them out. But because we're so disengaged, we don't know they're losing sight of the ball, and so we sit it out anyway and just simply fold our arms and say, yeah, it's going to happen anyway. So on that very positive note, I think we can call it a day. Thank you very much for coming.